I didn't say a word when the HOA president screamed about trespassing and illegal occupation. I just reached into my briefcase, pulled out the federal reclamation order with the Department of Veterans Affairs, seal still warm from the printer, and slid it across the conference table. Their lawyer went from red-faced bluster to pale silence in about 3 seconds flat. The room got so quiet you could hear the fluorescent lights humming overhead. That's when I finally spoke. "Ma'am, you can't sell federal property, especially when it was granted to a combat veteran under the Homestead Act." The look on her face was worth every sleepless night I'd spent in legal libraries for the past 8 months, 6 years earlier. I thought I'd found paradise. After 2 tours in Afghanistan and a medical discharge that left me with a bum knee and PTSD that made crowds feel like minefields, I inherited my grandfather's 40-acre plot in what used to be rural Montana. Grandpa Joe had homesteaded that land in 1962 under a special veteran provision, carving out a life in the timber country where the nearest neighbor was 2 miles away, and the only sounds were wind through pine trees and the occasional elk bugling. In the evening, the cabin he built wasn't much to bedrooms, a stone fireplace, and a wraparound porch that faced the mountains, but it felt like salvation after years of sand. Improvised explosive devices and the constant noise of military life. I spent my first year there just sitting on that porch, learning how to sleep through the night again without checking the perimeter every hour. My girlfriend Sarah would drive up from Billings on weekends and we'd fish the creek that ran along the southern boundary, cook over an open fire, and plan the life we wanted to build together. No deadlines, no politics, no people demanding things from me I couldn't give. Just peace. Finally, the trouble started on a Tuesday morning in October when I found a certified letter taped to my front door, Pines Ridge Homeowners Association. It said in corporate blue letters, followed by a notice of violation for unpermitted structures, non-conforming landscaping, and failure to register property with the association. I read it 3 times, thinking it had to be a mistake. I'd never heard of any homeowners association, and my land was miles from the nearest subdivision. The letter referenced ordinances and architectural standards for a community that, as far as I knew, didn't exist anywhere near my property, but it was my address, my name, and the violation fees added up to $1,200 with a demand for immediate payment. I called the number on the letterhead and got a chipper receptionist who informed me that my property had been incorporated into the Pines Ridge planned community, and that all landowners were subject to association covenants and architectural review. When I explained that I'd never signed anything and lived miles from any planned community, she put me on hold for 10 minutes before coming back to say the association president, Margaret Holbrook, would address my concerns at the next monthly meeting. I showed up to that meeting with copies of my deed,
my grandfather's original homestead papers,
and a surveyor's map showing my property boundaries. The community center was full of people I'd never seen before, all talking about mailbox regulations, and landscaping committees like these were matters of life and death. Margaret Holbrook turned out to be a woman in her 50s with the kind of aggressive cheerfulness that immediately made my combat instincts start humming. She listened to my explanation with a patient smile, looked at my documents for about 30 seconds, and then explained that when the county had rezoned the area for development 3 years earlier, all properties within the new district boundaries were automatically subject to association oversight. "It's really quite simple," she said, handing my papers back without really looking at them. "Your grandfather's homestead is a lovely bit of history. We're building a modern community here, and everyone needs to participate." She suggested I might want to consider subdividing and selling to developers, since my rustic lifestyle wasn't really compatible with their vision for the area. When I asked to see the legal documents that gave them authority over my land, she said they were available for review during business hours at the association office. 40 miles away in town, I tried to play by their rules at first. I drove to town, spent 3 hours in their office reading through covenants and bylaws that had been filed with the county, and discovered that my land had indeed been included in something called the Pines Ridge Master Development Plan. The paperwork was dense legal language that seemed designed to confuse, but the basic message was clear. They claimed authority over architectural decisions, land use, and even the right to assess fees for community improvements. I wrote careful. Emails pointing out that I'd never agreed to any of this, that my deed predated their organization by 50 years, that I had no interest in being part of their planned community. Margaret wrote back with increasingly condescending messages about community standards and property values, always ending with reminders about my unpaid violation fees. When I asked for a meeting to discuss my concerns, she scheduled it for the same day. I had a VA medical appointment I couldn't reschedule. When I asked to reschedule, she said I'd missed my opportunity and the matter was now in the hands of their legal department. The harassment escalated through the winter. They sent notices about my firewood pile being unsightly, my graveled driveway being non-conforming, and my pickup truck being commercial equipment that violated residential zoning. Each notice came with additional fees that they claimed were automatically attached to my property as liens. They demanded I remove a shed my grandfather had built in 1963, tear down a fence that marked my actual property line, and submit architectural plans for approval before making any repairs to the cabin. The worst part was the isolation. Sarah stopped coming up as much because she said the constant legal stress was affecting both of us. And I started avoiding trips to town because I'd run into their supporters who'd look at me like I was the troublemaker. My neighbors, the few, within 10 miles, stopped waving when they saw me. And I heard through the grapevine that Margaret was telling people was a difficult veteran who refused to be part of the community. By spring, I wasn't sleeping again, but this time it wasn't. Flashbacks keeping me awake. It was rage, pure and cold, at people who'd never served a day in their lives telling me what I could do with land my family had earned with blood. That's when I stopped trying to reason with them and started reading federal law. I spent weeks in the Billings Public Law Library working through homestead statutes, veteran land grants, and federal property regulations. What I discovered made my blood run cold, but not with anger this time, with the kind of focused clarity I'd felt during combat when everything suddenly made tactical sense. My grandfather hadn't just homesteaded that land under the General Homestead Act, he'd claimed it under a specific provision for World War II veterans that classified it as federal land granted to qualifying service members and their heirs. Deed was clear once I knew what to look for. The land was held in trust by the federal government and could never be subject to local zoning or private association control without explicit federal approval. More importantly, any attempt to sell, encumber, or transfer the property without going through the Department of Veterans Affairs was a federal crime. Margaret and her HOA hadn't just overstepped their authority, committed fraud by claiming jurisdiction over federal property. I spent the next 3 months building my case like a military operation, photographed every notice they'd sent, recorded every phone conversation, and documented every fee they'd tried to assess. I contacted the VA's regional office and discovered that not only was my land protected, but they had no record of any HOA being granted authority over veteran homestead properties in the entire county. The VA legal department was very interested to learn that someone was attempting to regulate federal property without authorization. Also discovered through public records requests that Margaret's HOA had been selling development rights to my land to a construction company based in Denver. They'd taken deposits from developers planning to build vacation homes on property they didn't own and had no right to sell. The paper trail was damning. Contracts, surveys, and architectural plans, all based on the assumption that they could force me off my land through fees and harassment. The federal reclamation order was beautiful in its simplicity. The Department of Veterans Affairs didn't mess around with local politics or homeowner association drama. The order stated that any claims of authority over the property were null and void, that all liens and fees were to be immediately removed, and that any further interference with the veterans' use of the land would be prosecuted as a federal crime. I had copies made on official letterhead and hand-delivered one to Margaret's office on a Thursday morning. I didn't call ahead or make an appointment. I just walked into the association office, set the document on the receptionist's desk, and said I'd wait while they read it. Margaret came out of her office 5 minutes later, looked at the federal seal, and tried to maintain her cheerful authority. "Well, this is certainly interesting," she said. "We'll need to have our attorney review it before we can make any changes to your account." I smiled and told her that was fine, but she might want to call the developers in Denver first, since the FBI's white-collar crime division was very interested in her real estate transactions involving federal property. The HOA collapsed within 6 weeks. Her grade resigned after their insurance company refused to cover federal prosecution, and 3 board members quit when they realized they could be personally liable for fraud charges. The Denver developers threatened to sue until their lawyers explained that you can't legally claim damages from purchasing something that was never for sale in the first place. The county quietly removed my property from the development district boundaries, and I received written apologies from 2 neighbors who admitted they'd been pressured to complain about my non-conforming lifestyle. Sarah and I got married that fall on the cabin porch, with the creek running beside us, and not a single person around to tell us our decorations violated community standards. The land is quiet again, the way it was meant to be. Sometimes I see cars slow down when they pass the old HOA office building that's now empty with a for lease sign in the window. I wave when they look my way, because I'm not angry anymore. I won, and everyone knows it.